All right, good morning, good afternoon, good evening, depending on when you are seeing this video. So, today we'll be taking a look at pre-trial investigation and police interview. Now, this would be like our fourth class in criminal litigation, and this particular class, after this class, we would still do some pre-class assignments, some pre-class tasks. For those of you that watched the last pre-class tasks, I'm sorry, I went live and I did it live. When I started rewatching it, of course, some of you complained in my DM, the ones that have my TikTok and my number, actually my WhatsApp number. Some of you complained that it's reached a particular point and the audio stopped. Now, I'm sorry about that. I went live. Whatever happened to be the reason that the audio stopped, I wouldn't know what that was. But that means I have to be very careful if I'm going live. And the reason I go live so that we'll do the pre-class assignment together is so that you would also impute. So please, anytime you see my notification of live, please join. So now we'll be looking at pre-trial investigation and police interview. Now, at the end of this lesson, students should be able to explain how to conduct pre-trial investigation, participate in a police interview, discuss how alibi, statements, and confessions are recorded at the police station. We also look at judge's rule, which of course is the basis of taking confession or statements from suspects, or witnesses. Then we'll look at how identification parade is conducted and how exhibits are handled. Then the student at the end of this lecture should be able to list and explain the constitutional rights of a suspect at a police station, and also explain how to apply for assistance for a citizen under the legal aid scheme. So if you are done with this lesson and you are not able to do 80% of these things listed here, then you have not gotten the value from this lesson. You have not gotten the value that this lesson was meant to give. Okay, we'll now look at rules and powers of the police. So when we look at the rules and powers of the police, we see that the police have powers, or one of the rules of the police, or one of the powers of the police is pre-trial investigation, as seen in the case of Hassan against EFCC, Onyekwere against the state. Then you look at Section 4, Section 31, and Section 84, Sub 1 of the Police Act. We also know that the police have the responsibility of preventing and detecting crimes. So that is under Section 52, Sub 1 and Sub 2 of the ACGL Lagos. We also have that the police have the powers to arrest offenders. You see that in Section 3 of the ACGA, Section 54 of the ACGL Lagos, Section 26 of the ACGL Kano, Section 32 Sub 1 Police Act, Police Act. So, and we also have that the police also have powers to prosecute offenders. You now see that in Section 66 of the Police Act. We'll look at pre-trial investigation. Now, pre-trial investigation is the first step that the police will carry out before arraignment in court. It is important that when an offense is committed, of course, before the police comes and say that he wants to arrest somebody, you must have finished your pre-trial investigation. Why? Because and I know, when we get to constitutional safeguards for defendant or accused, you will see that. It is different from suspect. Suspect is different from defendant. Suspect is different from accused. Suspect is somebody that has not been arraigned but was arrested. In fact, they are suspecting him that he actually committed the offense, but he has not been arraigned in court. Arraigned in court or arraignment is when they bring him to court and they read the charge and they say guilty or not guilty. They say guilty or not guilty. That is arraignment. But before they bring him to that court, he remains a suspect. You understand? So, pre-trial investigation is the first step that the police will carry out before arraignment in court. You cannot say that you are arraigning somebody in court without concluding on your pre-trial investigation. It is extremely premature that you now arraign somebody. Okay, what are the evidence now that you'll be using? What are the evidences you'll be using to prove beyond reasonable doubt that that person has committed an offense? It is during your pre-trial investigation that you'll be able to say, okay, these are the evidence we got from the pre-trial investigation, and as a result, this is the evidence we'll be using to prosecute this person. So I said there, the police and other law enforcement agencies are responsible for conducting pre-trial investigations. The duty of the police to conduct pre-trial investigations does not extend to debt collection and other civil wrongs like breach of contract. So this is very obvious. You must have heard this so many times that police powers do not cover civil wrongs. They do not cover civil liabilities. Civil liabilities are purely under civil law, and police have no business with civil relationships, like contractual relationships, like trust relationships, etc. You see that in McLaren's against Jennings, Iwe, and other authorities that are here. You don't have to come and be reading them out for you. Now let's go into alibi. What is the meaning of alibi? Alibi means elsewhere. 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 This is you were there when they committed the offense. They arrest you. You said, no, I was not there when they committed the offense. So that's a very good defense. In fact, it is the commonest defense usually raised by an accused person. Because once you tell the person that, see, I was not here when this thing was committed, there is no how they can say that you committed the offense if it is proven that you were not there at the time the offense was being committed. Do you understand? So it is a very common defense. Everybody uses it. But the problem now, while it will avail me and not avail you, is how you used it. And we'll look at how is it going to be used before you say that alibi has been properly used. Now, he said this is one of the commonest defense usually raised by an accused person or suspect. By raising the defense of alibi, the suspect is saying that he was not at the scene of the crime at the material time the crime was being committed, and that it was practically impossible for him to have committed the crime. So that's what I just explained. Now, when is the proper time to raise the defense of alibi? The defense of alibi is raised properly at the earliest possible time. So when they have told you that this is what we are arresting you for, at that time, that is when you are expected to say, see, this thing you are saying I did. I was not even there when they did it. When anybody that did it, did it. So it's going to be impossible. It's practically impossible for me to have done this thing you said I did when I was not there when it was done. So you must raise the defense of alibi at the earliest possible time. That time that they are arresting you, that time that they are telling you the reason they are arresting you, that is the time you are expected to say, I was not there when this offense was committed. Because if you raise it at any time after that particular time, it will be taken as an afterthought. It will be taken as, you don't have any other defense to do, you just came up with it, and it will not avail you. Now, how do you raise alibi? It's not just by saying I was not at the scene of the crime. You have to, after saying, I was not at the scene of the crime, you have to provide particulars. When I mean particulars, where were you? Who were you with? In what occasion were you? Like, you have to state in details your whereabouts as at the time the offense was committed. You have to provide the police or the people, the enforcement agents arresting you with the place, the particular time, the particular place, the purpose for which you were there, and the names of people you were with. The reason you are giving these particulars to the police is so that the police would be able to investigate your alibi. So it is not the responsibility of the police to investigate your alibi and disprove that your alibi. The burden of proof will be put on the police to disprove your alibi. So, number one is that in order for an alibi to be properly raised, it must be raised at the earliest possible time. And number two, it is not just only raised by saying I was not there when the offense was committed. You must have to provide particulars as to the time. You must have to provide particulars as to the place. You must have to provide particulars as to the people you were with. And you must have to provide particulars as to the purpose for which you were there. Now, what is the police expected to do with the particulars furnished? Of course, I've already stated it. Once alibi has been properly raised, in that particulars were supplied, the police are required to investigate the alibi. This can come as an MCQ question in law school. What is the police expected to do when you must have provided the particulars for alibi? Very simple. To investigate the alibi. In certain cases, investigations may be irrelevant. Now, there are cases where investigations are not relevant. You are saying that you are not there at the scene of the offense when we caught you at the scene of the offense. What do you mean you are not there at the scene of the offense? The place we arrested you was at the scene of the offense. In that situation, even if you give them particulars, of course, it's going to be taken as a lie, so there's no need to investigate. Okay. Example, where the accused or suspect was caught/arrested while committing the crime, or at the scene of the crime, or was pursued and arrested immediately after committing the offense. Another circumstance where investigation may not be needed is where there is a voluntarily made confessional statement. The confessional statement may destroy the defense of alibi. So, apart from the fact that they caught you red-handed when you were committing the offense, if you have given a voluntary confessional statement that yes, so I was the one that committed the offense that I was being arrested for, and you now turn back and you are telling them that you were not at the scene of the offense, there's no need to investigate now because the confessional statement is already there. So it is taking that you coming out to say that I was not in the scene of the offense when it happened was an afterthought. Maybe that's what your lawyer have told you to do. To lie that you are not there so that they will avail you. So the confessional statement, since it is voluntary, of course, if it is not voluntary, we'll come to that. We'll look at confessional statement in this lesson. So since it is voluntary, it will disprove that your alibi that you are trying to raise. Okay, remember I just said now that will come into confessional statement, and here we are. Statements and confessional statements. Now, what is a statement? A statement is a narration of facts relating to a case. You now see that they will invite some witnesses, and some witnesses, or maybe you that you call the police to arrest somebody that committed an offense against you. The police will say they want to take your statement. You understand? So, what are they taking by taking your statement? They're taking the narration of facts. What happened? What led to what happened? Or what happened that you are calling the police to come and arrest somebody? What happened? Or how did the offense start? A narration of facts relating to a case. So somebody stole something. Oh, I was sleeping in my house, and when I immediately woke up, I saw somebody's hand coming into my window, and immediately I just held the hand and I heard the voice of Mr. Mbeke, and Mr. Mbeke was the person that is being arrested. These are facts. These are narration of facts, and they are statements. A confessional statement is an admission of guilt. So yes, I actually committed the offense. Confession. From confession. Confessional statement. I committed this offense. Yes. So that's a confessional statement. So Igbo against the state, see section 28 of the Evidence Act. So guiding principle in obtaining / tendering statements from a suspect. Okay, when you want to obtain a statement, the police wants to obtain a statement from a suspect. These are the principles that should guide the police people or the police person that is taking the statement. Number one is caution. Statements must be made under caution. The suspect should be cautioned as to his rights. The suspect should be told, see, you have your right to remain silent. You have your right to a legal practitioner. They are supposed to caution the suspect and say that you need not make this statement now. But if you want to make the statement, it is voluntary on your own part. You can also be silent until your lawyer comes. So you must have to caution the suspect as to his rights. That is one. English. Statement should be obtained in English language, if practicable, except the suspect does not understand English. Then the police should allow the suspect to make a statement in that language. Now, when the statement is taken in that language, an interpreter is expected to translate the language to the language of the court. So, when a statement is taken in another language, we need the language to be in the language of the court, which is English language. So, we would need an interpreter whose particulars shall be stated. So that interpreter is not just coming to interpret. You have to state the particulars of the interpreter, the name and everything. And the interpreter will have to sign. That is in the case of Adeyemi against the state, or Lekan against the state. Section 17, subsection 3 of the Administration of Criminal Justice Act. Go and read it. So we have the pronoun requirement. Of course, it is you that is writing the statement. Of course, the pronoun should be in first person pronoun. I think that's what it's called. First person pronoun I, we. See amend against the state. Now, in tendering statements recorded by an interpreter, the interpreter must be present and it must be admitted through him. It must be admitted through the interpreter because it's the interpreter that is the maker of that statement, even though he was interpreting a statement. Because if the interpreter is not there, it will be taken as documentary hearsay. Let me slow down. In tendering statement recorded by an interpreter. So when you speak in Igbo or in Yoruba and an interpreter interprets it in English, if they want to tender the statement in court, this interpreter must be present and it must be admitted through the interpreter. So the suspect is not the person that would tender the confessional statement or the statement. Since it was interpreted, it must be from the interpreter because the interpreter is the maker of that document. So both the statement, both the statement and the interpreted version must be tendered. See the case of Wanle against the state. So now listen. When it is not an interpreted statement, it is not mandatory for the police officer that recorded the statement to be in court before the statement can be tendered and admitted. So, if it was not an interpreted statement, maybe the suspect spoke in English and it was written in English, the police that wrote down the statement need not to be around, just like if it was interpreted. I don't know whether you understand what I'm saying. So, if it was said in a language another language and it was interpreted to English, the person that interpreted it should be there, should be present when it is being tendered in court. However, if it was not interpreted, if it was spoken in English and the person that wrote it, that's the police officer that wrote the statement, was writing as it was being spoken in English, the police that wrote it need not to be there for it to be tendered, since it was not interpreted from a language to another language. It was just written in English and it was stated in English. Okay, now, what if the interpreter has died or cannot be found or is incapable of being in court? What happens? Now, if that happens, the prosecution would lay proper foundation in court. The prosecution will have to state that these things have happened, and so it was impossible for the interpreter to be around. So in that circumstance, it can be taken without the presence of the interpreter. However, if the foundations are not laid, or if the foundation is not laid, then the document or the statement cannot be admissible because it will be seen as hearsay. So we look at endorsement by suspect / attestation by interpreter. Under the ACJA, where an interpreter records and reads the statement of the suspect over to him, to his understanding, the suspect shall then endorse the statement as having been made by him, and the interpreter shall attest to the making of the statement. So the interpreter finishes interpreting and reads it over to the illiterate. If the illiterate say, okay, this is actually what I said, yes, it is the correct thing, it is correct, the suspect shall now endorse that, see, this is me, I made the statement, it was voluntarily made by me, and the interpreter shall now attest, attest means to witness the making of the statement. Look at section 17, subsection 3 of the ACJA. Availability of material evidence. All material evidence must be made available to the suspect. So all the evidence you want to use against the suspect, you must have to show him. You don't have to take him by surprise. That is when you are getting a statement. Foundation. Statements made to the police by the suspect during investigation must be tendered by the police at trial, and it is the foundation of the case. And such statements are admissible. See the case of Igbo against the state. Verbatim. The statements must be verbatim record. You don't choose what to write. The statement must be as it is, as the person that have written it or stated it should be. Verbatim et literatim. Voluntary. It is not mandatory for a suspect to make statement to the police. And as such, the suspect only makes a statement if he wishes to. Otherwise, he may refuse to answer any question put to him or make any endorsement on any statement, even after consultation with his lawyer. So, section 35, sub 2, section 32, paragraph E, ACJL, and section 6, subsection 2, paragraph A of the ACJA, you have your right to not make any statement. This is what some people don't want you to know. You have your right to not make any statement. Now, principles relating to confessional statement. Okay. First of all, confessional statements are regulated under Section 28 and 29 of the Evidence Act. No confessional statement can be made during trial. Of course, when you are making a confessional statement during trial, it's as good as saying you are guilty of the offense. So it need not to be a confessional statement. Just say you are guilty and you go in for it. It can only be made, confessional statements can only be made during police investigation or at the close of police investigation. Should an accused confess to committing a crime during the trial, or committing the crime during the trial, it shall amount to guilty plea and not confession, just like I stated. So, confessional statements are made pre-trial. If you make a confessional statement that you committed the crime during trial, it means you are saying you are guilty. And no, all those tendering of confessional statement, you cannot even call it confessional statement because you are actually saying that you are guilty. Confessional statement that you tender in court for the court to look at in order to arrive at a decision is made pre-trial. But if you are making confessional statement during the trial, it is a guilty plea. Okay, confession could be oral or in writing. Now, it should be noted that oral confession is not admissible in Lagos. However, under the ACJA, it is admissible. See section 15, subsection 5 of the ACJA. It is not admissible under the ACJA Lagos. I've said this one now. Before they will not tell you that in the exam, there was an oral confession that was made, comment on the validity or otherwise in Lagos. So you not tell them that yes, it is because you heard oral confession is admissible. It is not admissible in Lagos, but in Abuja it is, in Agja it is. A confessional statement cannot be made on behalf of another person. See the case of Mba against the state, Olusegun against the state. You cannot make a confessional statement against another person. You have to make it only for yourself. The confessional statement must be made by the suspect or accused. The confessional statement of suspect A cannot be used against suspect B, except suspect B, in whose presence it was made, adopts same by words or conduct. See section 29, subsection 4 of the Evidence Act. So suspect A cannot go and make a confessional statement and rope suspect B inside. and you think that that confessional statement should be used to convict suspect B. But it can be a confessional statement of suspect B if suspect B adopts suspect A's confessional statement in both words and conduct. Now look at grounds for objection. What would happen and you would object to the admission of a confessional statement? On what grounds can you object to the admission of a confessional statement? You can object in the circumstance of involuntariness or in the circumstance of retraction. These are different. Now, when you object to the involuntariness, what the court will do is to order a trial within trial. A trial within trial is in order to know if it was actually made voluntarily, if the confessional statement was actually made voluntarily. However, if it is retraction, the court will admit the confessional statement, then ascribe probative value to the statement and attach necessary weight based on evidence before the court. So these are different. Involuntariness is they forced me to write this confessional statement. They forced me. It was not by my voluntariness. It was not by my voluntary power. So if that is the case of the suspect or the accused or the defendant, what the court will do, the court will not just throw it away and say, it was not him that just, let us throw it away because it was not him. No. The court will have to order a trial within trial. And that trial within trial is to ensure the police will have to call witnesses, the defendant will have to call witnesses in order to ensure and in order to prove that it was made voluntarily. The confessional statement was made voluntarily. And so if after they've tried within trial, the court comes to a conclusion that it was not made voluntarily, then the confessional statement will not be admissible. Now, that is for involuntariness. Trial within trial is ordered. Now, if it is a retraction, now, we are saying you did not make the statement. Remember, the involuntariness is that I made this statement, but it was not my own making. It was them that forced me. They even pointed gun at me and said I should make the statement. Involuntariness. Retraction is that, I did not make the statement at all. They just manufactured it and they signed it and they brought it to my notice. So I did not make the statement. So when that happens, when retraction happens, when you deny that you did not make this, that you made the statement, you deny I did not make the statement, the court will admit the document, will admit the statement, but now look at other corroborating evidence that have been tendered for that case and know the weight to give the confessional statement. Now, when is the right time to raise objection? No matter the objection you are raising, whether involuntariness or retraction, when is the right time to raise it? An objection to an involuntary confessional statement should be made timeously. It should be made at the point the prosecution seeks to tender the evidence, the statement as evidence. The objection to the admission of a confessional statement is to be raised when it is sought to be tendered. So you cannot, after it's been tendered, you do not say anything and you now come later to come and object to the admissibility of that evidence when it has already been admitted. No, you are objecting to the admissibility. So it must be done at the point it is being tendered. If you don't object to the tendering of that confessional statement at that point, then you have lost it. You have slept on your right. So the particular time for tendering is when you object, you raise objection. Now, what are the effects of confession? A confessional statement is sufficient to ground a conviction. You see, one of the ways to ground a conviction is by a confessional statement. One of the ways to actually convict you is when the confessional statement is made. Of course, you have ways to convict an offender of the law. Number one is by direct evidence of an eyewitness. Number two is the circumstantial evidence. Then we have the confessional statement of the accused. So even without corroboration, confessional statement can ground a conviction, provided the court is satisfied with the truth of the confession, even if it is inconsistent with the accused statements in court. So if the court is satisfied that this confession was actually a confession that was made voluntarily, then the court can act on it. Notwithstanding the fact that in the statement in court, they have now told him that no, you cannot use, you have to say that you are not there. No. The court will have to look at the confessional statement and be sure that it was actually made voluntarily. After being sure that it was actually a voluntary confessional statement, then the court can ground conviction on it and convict the offender on it. Okay, so we look at identification parade. When is an identification parade essential? So is it every time that somebody is arrested that you see the identification parade being conducted? No, the Supreme Court in Ikemsen against the state stated that identification parade is only essential in the situations enunciated in Arrow versus Turnbull and others. Now, what are those situations? Now, the situations referred to in Aro against Stumble and others are as follows. The victim or witness did not know the accused before, and his first contact with the accused was during the commission of the offense. The victim or witness was confronted by the offender for a very short time. The victim, in the time and circumstance, might not have had full opportunity observing the features of the accused. So, these are the circumstances where that would present itself before identification parade can be ordered. So we look at some instances where identification parade is not necessary. Number one, is not necessary whereby his confession, an accused person identify himself as the offender. So where by his confession, so the person has said that he actually committed this offense. So there's no need to come and start identifying who actually was the person that committed the offense, because his confession has already stated that he committed the offense. Where the offender is arrested at the scene of the crime, of course, while committing it, there is no need to order an identification parade, because identification parade, the reason for identification parade is to identify the person that actually committed the offense. Where the offender was well known to the witness or victim before the commission of the crime. Where this is the case, any parade conducted will be for recognition and not identification, as in the case of Samuel Bozin against the state. So when I know this person that came to steal from me, I had already known him. Remember that one of the circumstance where identification parade is necessary in the case of Aro against Turnbull is when you did not know the suspect or the accused before that time. So that means it would not be necessary if I had known him before he came and committed the offense. So even if they are trying to conduct any parade, it would now be for recognition. Let me see whether he's part of the people that are there, because I already knew him before then. Where the case of alibi has been put forward by the suspect. So if the case of alibi has availed the suspect, it will not be necessary to do that. Where there is a strong and uncontradicted eyewitness account showing the offense was committed by the accused person. So there is a strong eyewitness account, very uncontradicted. It is not necessary. It will not be necessary for identification parade to be conducted. Where the circumstances of the case has sufficiently and irresistibly married the offender to the crime and the crime scene. So that is another, So we have types of identification. We have the dock identification. If the accused is in the dock, the witness can be asked if he knows the accused. Say, yes, I know. Voice identification. If the accused/suspect made a lot of speech while committing the crime, then they can just tell them to say something so that the victim can listen to them, or the witness can listen to them and say, okay, this was the voice I heard and this was not the voice I heard. Photograph identification. So they need not to be there, sir. You can just bring out the photographs of all of them and say, okay, which one was there? To you now point at it. Spontaneous identification. Say, this is the person, without even organizing the identification parade. We have fingerprints identification, we have handwriting, thumbprints, etc. See the case of Emenego against the state or Achibong against the state. Now look at procedure for conducting identification parade. Very important. Now, presence of a senior officer. A senior officer must be present, and he's not to take part in the identification parade. His presence is only needed. No officer is expected to speak with the witness or complainant except the officer in charge, and any such communication with witness/complainant must be audible. Now, the identification parade must consist of at least 8 persons plus the suspect, who as far as possible resembles the suspect in age, height, build, complexion, general appearance, and position in life. So if you want to organize an identification parade, there must be 8 persons plus the suspect who look alike. So if a police officer forms part of the identification parade, his badge number must be removed, so that you actually identify him by his features and not his badge number. Before parade, witness must not see these persons to be paraded before the parade. The suspect must be handed Form D48. The form consists of information in relation to his rights during the identification parade. Some of these rights are right to have his legal practitioner/friend or family member present at the identification parade, right to take any number/position in the identification parade, right to be asked whether he is satisfied with the identification parade, that is, whether he has any objection to the arrangement for the identification parade or to any of the participants in it, and to state the reasons for his objection. Okay. Exclusion of those directly involved/the press, so they will be excluded, the press and people that are directly involved. Line-up photograph is taken before the parade begins, so they have to take some photographs. These are the procedures I'm reading out to you. Communications between witnesses before parade is prohibited, so you don't communicate with anybody before the parade. Hand placing on shoulder rule. If the witness identifies any of those paraded, the witness must place his hand on such person's shoulder, and photographs of such will be taken. So you place your hand on the person's shoulder once you have identify the person and they will not take your photograph. If there is more than one witness, they must be brought in one after the other. Identification must then be done individually. Very important to me. After identification, another identification parade is to be taken with the person identified with different persons for the purpose of verification. So you must verify that was actually the person that committed the offense. There should be separate entry and exit to the venue for the identification parade. These are the procedure, and it comes out in exams. The room for identification parade must be well illuminated. Where the suspect has an unusual physical feature, such as a facial scar, a tattoo, or a distinctive hairstyle or color or hair color, which cannot be easily replicated by other participants in the identification parade, steps should be taken to conceal that special feature. After the entire parade, forms D49 and D50 will be completed by the police officer in charge. So that is about that. Next, we go into exhibit handling. Now, when the investigation is going on, some items will be seized. Such items are to be preserved for the purpose of conducting trial and prosecution. So you must have to preserve those items, which would probably form part of evidence later in the trial. There is usually an exhibit list, which would itemize all the materials collected from a suspect. You also have exhibit register, where exhibits collected and in police custody are recorded. There is exhibit keeper, the person who keeps custody of all the items in the custody of the police. There is now the exhibit room, where the exhibits are kept. The exhibit room must be a secluded place and can only be entered by authorized/designated officers. Items which are seized by police officer requiring laboratory or forensic test is usually packed in an exhibit pouch. So take note of all the things that I'm saying. Procedure for recording inventory of property of arrest person under ACJA, section 10 of the ACJA. Read section 10 of the ACJA. Then you see the procedure. No need to go over it. Just gonna read section 10 of the ACJA. So now we'll go into the constitutional rights of the suspect at the police station. So you read section 35. All the provisions in section 35. Section 36, subsection 5 and subsection 6b of this constitution. So we'll go into legal aid scheme. Who is qualified to assess legal aid? Section 10, subsection 1 of the Legal Aid Act provides that only persons whose annual salary does not exceed the national minimum wage are eligible for legal aid. So if your annual salary does not exceed the minimum wage, then you are eligible. If your annual salary exceeds the minimum wage, then you are not eligible. Okay. Now, application for legal aid is made to the Director General of the Legal Aid Council, stating the income of the client, belief that the person is entitled, and justiciability of the matter. The court can also refer a matter to Legal Aid Council through form number LAC1. Legal aid is absolutely free. The legal aid scheme is administered by the Legal Aid Council, and its main responsibilities are legal aid and advice through criminal defense. When you look at section 7 and the second schedule of the Legal Aid Act, you see the particular offenses that Legal Aid Council is interested in. Now, in the South, we have murder, manslaughter, malicious wounding, or inflicting grievous bodily harm, assault, occasioning actual bodily harm. Now, in the North, we have culpable homicide punishable with death, and that's not punishable with death, grievous tort, criminal force occasioning bodily hurt. Now, generally, we have common assault, affray, rape, and stealing. So, you have to look at section 7 and the second schedule of the Legal Aid Act. This is an example of an application for legal aid. Learn this thing. You will be asked in exam to draft it. Learn this. Look at it very well and try to draft it yourself. With that, next video will be on pre-class tax. We will now look at the tax class. Now, I did not really talk about judge's rule, so you have to read it yourself. Judge's rule, you have to read it yourself, so that when we are doing the pre-class tasks, you would know what we are doing. So with that, thank you very much for giving me your time.